morning, friends from the media. Welcome to this morning's 11 o'clock press conference. The chief executive will first speak before answering questions. Because of the epidemic, I ask you all to keep your masks on and stay socially distanced. We'll first hear from the chief executive. Friends from the media, people of Hong Kong, yesterday, the 30th of March, the Hong Kong SAR government has launched a new campaign to fight the epidemic. In that campaign, COVID supply kits will be distributed to everyone in Hong Kong. As you recall, in our fight against the epidemic in the past 2 years, I've often said that in order to protect public health, we need the support of each and every one of you. And in our fight against the fifth wave, this territory-wide support is much needed. So the distribution of the COVID supply kit is not just to distribute much needed supply to people of Hong Kong. There is another significance. At this moment of time, in this moment of time, we need to strengthen the support of our community, and we need to work together. I do believe that after the epidemic, the same strength will prop us up in our road of recovery. Yesterday, I've made some visit. I could feel the strong solidarity. First, I went to visit a holding center at the Kai Tak cruise terminal. And I've also visited a packaging center of the COVID supply kit. I cheer our colleagues up and watch them work. Well, I say that the Kai Tak Cruise Terminal Holding Center manifests our strength in solidarity because this holding center is set up for elderly people who live in residential care homes and have been infected with the virus. They could be swiftly removed from the care home for isolation and treatment. The elderly people of this category are either without any symptoms or with mild symptoms, but they need medical surveillance. The Permanent Secretary of the Labour and Welfare Bureau led a working group. We have members from the Department of Health as well as the Social Welfare Department as well as the Hospital Authority. Clear guidelines have been set down under which when a resident of a care home for the elderly is infected, there is no need for that person to wait at the A&E department. The person could be sent directly to the holding center. Another function of the center is for elderly people who have been discharged from hospitals. They have received COVID treatment, but they might not be able to send back to their own home or care homes so they can be cared for at the holding center before it's suitable for them to do so. And yesterday, well, maybe because of a communication hiccup of the hospital authority, there was a concern about whether COVID oral medications could be used at these holding centers. The answer is yes, they can be. Yesterday, together with Dr. Tony Ko, we went to the Kai Tak Cruise Terminal Holding Center. And I asked this question, and the answer is in the affirmative. Medical centers or institutions have been in good liaison with these holding centers to prescribe COVID oral medication. For people who are staying at these holding centers, they are the most suitable category to be prescribed with such medications to avoid serious cases of fatality. So I, on behalf of the hospital authority, clarified that at these holding centers, these COVID oral medications could be used with a prescription by doctors at holding centers. The holding center at Kai Tak is the largest It carries 1,200 beds. With support from different fronts, that is, healthcare as well as social welfare. The center is managed by the Social Welfare Department. There are different parts of that manages these beds with the support of Toma Groups of Hospital and the Haven of Hope Hospital. In terms of healthcare and medical, we have Chinese medicine clinics of the universities and medical teams of universities, as well as the support of the mainland medical team. There is sufficient manpower to enable smooth operation. Treatment using Chinese and Western medicine have been used, and there are also a gerund technology being applied to help elderly people. On top of that, we have counseling services available. Staff members will be given some drinks, some remedy developed by the Hong Kong University. Previously, I have said that in our fight against COVID-19, and upon our requests, central authorities send mainland experts in Chinese medicine to come to help us. It has paved a new way for its development. And indeed, in the Kai-Tak Holding Center, we have seen an opportunity for the application of clinical TCM, traditional Chinese medicine. It's very rare that you see TCM practitioners prescribing medicine and giving consultations at medical institutions, but this has been taking place in the Kai-Tak Holding Center. I believe that this is a very good experiment for the future Chinese medicine hospital. And the Chinese medicine hospital, after a tender exercise, has been awarded to the Hong Kong U for operation. Family members with elderly people being infected, we will provide suitable care and services to the elderly people at these holding centers. And these holding centers are not just simply holding centers where people stay. It is also a place for them to recover. Another area of work is packaging of COVID supply kits. It's been going on very smoothly. And we have even exceeded our target. Our plan is to pack 3.5 million kits over 3 days. Yesterday, we have operated 130 packaging centers. We have completed 1.6 kits. That is, we have already completed 45%. So we have exceeded our target. I am grateful to all the volunteers, organizations, legislators who have helped at these packaging centers. According to our plan, on Saturday, that is the 2nd of April, we will start our territory-wide distribution of COVID supply kit. Our goal is to complete the whole process within 7 days. If it's a public housing estate, it will be done by the housing authority. For private residential complexes, we will get the help of management companies and owners corporations. In relation to those buildings without any management, then we will ask civil servants to go to distribute the kits door to door. And we'll also engage rural committees as well as district councils to distribute the kits to people living in villages. Those who have no access can get their supply kits at the distribution stations dotted all over the territory. And that is my opening remark. We'll now answer questions.
The floor is now open, and if you want to ask a question, please raise your hand. And when you're called, please use a mic, introduce the media organization you represent. This is Mary Potter over here. Chief Executive, good morning. I'm from Phoenix News. In the past week, the single-day confirmed case number has been on the drop. Are we going to still have the comprehensive compulsory universal testing? And if the answer is in the affirmative, how much time will be needed for preparation? Recently, you have raised the penalties for breaching social distancing measures. Is it a preparation for the CUT? And then in relation to the non-permanent judges of the CFA of Hong Kong, they're going to resign. Do you think that this will lead to resignation of other judges? And how do you make sure that this will not affect the judicial independence of Hong Kong? The first question relates to the recent epidemic situation. We have observed a continuous decline in the number of confirmed cases, but then the extent of decline is only moderate, and we therefore need to further observe the situation. Now, today the figure is below 7,000. You may feel relieved after a spike of cases over 10,000 for several days. Still, we should be vigilant. There are 7,000 cases that require follow-up action, such as confirmatory tests and home support, etc. So this is still quite a significant number. Now, as I explained before, the best time for rolling out a CUT is at this initial stage or at the end of an epidemic. Now, we still have 7,000 cases, so we have yet to reach the end of the epidemic. But very soon, we will be making an announcement. Since we are distributing numerous RAT kits in our anti-epidemic service bags, we would like to explore whether we can make use of this convenient and accurate tool of rapid antigen test kits so that we can gauge the epidemic situation more accurately in Hong Kong. In relation to updating the penalty levels, earlier, the Food and Health Bureau issued compulsory testing notices. And earlier, the Bureau raised the financial penalty level from $5,000 to $10,000. And this is just an exercise to raise the corresponding penalty levels of other similar social distancing measures. It doesn't relate to the CUT. For social distancing measures, if we continue to see the epidemic situation being stabilized with a continuous decline, then there is light at the end of the tunnel, and I believe that all sectors of the community would like to see a relaxation of social distancing measures by the 21st of April. So I don't think that we should casually just tighten up the social distancing measures again, because I would say that these measures have really impacted on people's daily living. The second question, of course, is a matter of great concern of reporters here, so I would like to give a more detailed reply. Last night, the Hong Kong SAR government issued 2 press releases. The first one explains my own view on the 2 judges' resignation. The second press release relates to a debate that was held by the House of Commons in relation to Hong Kong's rule of law and judicial independence, and we'd like to make our stance clear. I understand that the Chief Justice also issued a press release. My press release, similar to the Chief Justice Carrie Lam's or Andrew Chang's press release, state that in relation to the serving non-permanent judges, Lord Robert Reid and Lord Patrick Hodge, we note with deep regret in relation to their resignation. I also am disappointed. In the press release, basically, the Hong Kong SAR government makes clear its position in relation to the judge's resignation. I am the organ, or rather the authority for appointing judges at different levels of court, but I'm in no position to stop the resignation of any judge. So we have no alternative but to accept their resignations with much reluctance. However, to say that the two judges' resignation has to do with the Hong Kong people's freedom and the national security law, we must staunchly object to these allegations. We accept their resignations, and we must thank these two judges who started to serve the Court of Final Appeal of the Hong Kong SAR as non-permanent judges since 2017 and 2021 respectively. I have a number of points to supplement in relation to the press release issued last night. In relation to independent judicial powers, including that of final adjudication, these are spelled out clearly under Article 2 of the Basic Law. This is one core principle of one country, two systems, and Hong Kong people administering Hong Kong. That is why this is listed under general principles in Chapter 1 of the Basic Law. Since reunification, the Basic Law forms the backbone of our legal system. It has nothing to do with a Sino-British joint declaration. Our judiciary is enshrined with independent judicial powers, and this is enshrined in Article 80 of the Basic Law all the way to Article 96 of the Basic Law. These provisions relate to independent judicial powers of our judiciary, and let me cite a number of them. For example, the courts of the Hong Kong SAR shall adjudicate cases independently, and this is Article 82 of the Basic Law. And Article 88 of the Basic Law provides that an independent commission should be in charge of making recommendations for appointment by the Chief Executive, and this is the Judicial Officer's Recommendation Commission. The other important article is that the Court of Final Appeal of the Hong Kong SAR may invite judges from other common law jurisdictions to sit to the Court of Final Appeal, and this is Article 82 of the Basic Law, and this is also the basis on which we invite judges from and eminent judges from other common law jurisdictions to accept the appointment by the Chief Executive to be non-permanent judges of the Court of Final Appeal of the Hong Kong SAR. For non-permanent judges serving the courts of Hong Kong, they preside over cases independently without fear of favor. Now, for non-permanent judges taking part in and presiding over the ruling of cases in Hong Kong, they support the legal system and the judiciary of Hong Kong, including the court's powers of final adjudication. It is not a sign of supporting the administration of the Hong Kong SAR. I appointed 5 non-permanent judges of the Court of Final Appeal. I attach great importance to their work, and I'm very grateful. This is exactly because they support judicial independence in Hong Kong. I've never said that By accepting my appointment as non-permanent judges, they are supporting the executive. Their appointment is a sign of supporting judicial independence in Hong Kong. I also had the honor to be the Commissioner of Oath for the appointment of judges. Now, first of all, judicial independence is enshrined in the Basic Law, and as the Chief Executive, I will also defend the judicial independence of Hong Kong's courts without fear or favor. Yesterday, one of the judges who resigned, Lord Patrick Hodge, was only appointed in January 2021. And in other words, by then, the Hong Kong national security law had been promulgated for 6 months, and he came to Hong Kong for a visit in November 2021, and I was the Commissioner of Oath. And that is why he also supported Hong Kong's judicial independence. The wording of the judge's oath is that they bear allegiance to the Hong Kong SAR, then they are here to serve the people of Hong Kong. There is never this requirement for them to support the executive of the Hong Kong SAR government, or that they should support any policy introduced by the executive. That is why I feel perplexed about the allegation. According to this allegation, if they don't resign, they will be deemed supporting the executive.
Administration. 咁如果你聽到我頭先
So you will see, since I've explained, that this is irrelevant. Their appointment has to do with their support for the independent judicial system. Nothing is said about supporting or endorsing the executive. Therefore, it is wrong to allege that they can no longer serve the judicial system because of the executive's issue. And now I understand that there is another Canadian judge who is at the moment a serving non-permanent judge, Justice McLaughlin, and she has been asked whether
to the administration.
Whether her participation is recognition of the administration, and her reply is that she denies categorically. That, in other words, her appointment has no connection with the administration.
咁所以點解會有一個
That is why the allegation of resigning at this stage has very much to do with the administration is unfounded. In the past 10 hours or so, after the news of the two judges' resignation have been circulated, I read the responses from members of the legal profession and members of the community. All in all, I would say the following, and that the resignation is politically motivated, that they have been put under political pressure, and that this is a kind of political manipulation. And I have reason to suspect that these allegations of political motivation are true.
The judges resigned on the 30th of March. And in the same hour, what happened was that in the House of Commons in the UK, there was a debate on this issue, that is, the rule of law in Hong Kong, and whether UK judges should get involved in trials in Hong Kong. And at a similar time, the UK government issued a statement saying that they would not support serving judges to become non-permanent judges of the CFA. And then the Minister of Foreign Affairs of the UK said that this is a tipping point. That is, UK judges should not continue to serve in Hong Kong judiciary. And in about noon that time, in the Prime Minister's Q&A time, the Deputy Prime Minister said that it made it impossible for them to serve. I've just received a notice that the Minister of Foreign Affairs of the UK will shortly afterwards submit a 6-month report of Hong Kong to the Parliament. So this spate of incidents inevitably gave us the impression that it is just political choreography. And it's quite obvious that some executive of some politicians would like to override the decisions of or to interfere in the decisions of judges. It is plain as day. So UK officials and politicians took measures to undermine our much respected judicial system. Is an act that I find extremely regrettable. But I can say to you all that protecting our independent judiciary is the constitutional duty of our courts and that of the chief executive. And I have confidence that judges serving at different levels of our courts will, as usual, be free from political interference and manipulation. They will, as usual, uphold the oath they took when they started their office. That is, they will uphold the basic law and they will, without fear or favor, serve the Hong Kong SAR government. Second reporter, the one in light blue.
South China Morning Post first. Firstly, we'd like to ask about the flight bans being lifted tomorrow. A lot of people are obviously excited about this. So is there going to be enough manpower to take arrivals from the international airport to the designated quarantine hotels? Previously, even before the flight bans, people wait hours or even up to a day to be sent for their on arrival test to be approved, and they can be escorted to their accommodation. And can you give us a figure on how many flights are expected to come in from the 9 countries tomorrow? And is that a figure that is a lot, or do you gauge that as not significant at the moment? And also, can you relay if you are worried or not that the recent resignation of overseas judges will affect Hong Kong's reputation will affect Hong Kong's judicial independence reputation?
Thank you for the 2 questions. First, yes, tomorrow on the 1st of April will be the first day that the Hong Kong SAR government has lifted the place-specific flight suspension in respect of the 9 countries. I haven't got the latest figures, but the figures that I was given yesterday indicated that there should be over 20 flights with over 2,000 passengers coming back to Hong Kong. That is disregarding the transit passengers, because on these flights we could have transit passengers, but arrival passengers landed in Hong Kong should be about 2,000. But as I said, the figures could be changing every moment. Now, we have taken it very seriously to make sure that the whole process of people, Hong Kong residents arriving and then taking the test and hold, the PCR test at the airport, and then transported to the designated quarantine hotel is a smooth process. That's why an interdepartmental meeting has been held yesterday, chaired by the Chief Secretary for Administration, to make sure that we have the capacity, we have the staff, and the testing contractor will be geared up to look after the several thousand passengers arriving, and also the transportation, because we have to arrange designated transportation. So I can tell you that we have made full preparation for their return, and I hope that they will all have a pleasant trip back to Hong Kong. I should just mention that the anti-epidemic bags that we are packing in yesterday and today and tomorrow would also be made available to these Hong Kong residents coming back, probably at the hotel, so that they could also do the rapid antigen test. And if they have a negative test on day 6 and day 7, and then a PCR negative test on day 5, they could be discharged from the designated quarantine hotel. Now, about the resignation of the 2 UK judges who have been serving on the Court of Final Appeal of the Hong Kong Special Administrative Region since 2017 and 2021, respectively, I, together with the Chief Justice of the Court of Final Appeal, have expressed regret on their resignations, because non-permanent judges from common law jurisdictions are playing a very valuable and useful role to Hong Kong, and is a vote of confidence in the judicial independence of Hong Kong. So it is something to be regretted that they have decided that they have to leave. But what I find very disturbing, and I could not accept, is the association of the judges' resignations with either the implementation of the national security law or the practice of individual rights and freedoms in Hong Kong. The rule of law has remained as robust as ever in the past 25 years after the unification. The national security law is a very essential and legitimate piece of legislation to restore law and order in Hong Kong after what we have gone through in the latter part of 2019, with a spate of unprecedented riots all over the territory. And every country has a national security law. Our national security law is much narrower in scope and is very clear on the 4 types of offenses. And our national security law is perhaps one of the few worldwide that allowed non-Chinese national judges to adjudicate, right? In most jurisdictions, if you want to sit on a case concerning that country's national security, I gather the basic requirement is the judge has to be a national of that country. But in our case, because of the provisions in the basic law, and we do have a lot of non-Chinese national judges sitting not only in the Court of Final Appeal, but at various levels of the judiciary. So the NSL, the Hong Kong National Security Law, does not prohibit overseas judges or expatriate judges to adjudicate on cases concerning the national security law. So now to use that excuse as a reason of no longer sending out judges, serving judges to sit on the Court of Final Appeal is totally untenable. Yeah. And there is also a misperception that judges, overseas judges sitting on the Court of Final Appeal is a legitimate endorsement of the government. That is never the case. I would suggest you can go back to all the documents we issue about the appointment of CFA judges. They are much valued in helping Hong Kong to safeguard judicial independence. They are not lending us any legitimacy. Us means the administration. So to suggest on this occasion that they could no longer sit on the Court of Final Appeal because to do so would appear to endorse the administration is a very fallacious argument. And I can only draw the conclusion that there must be quite a lot of politics behind it. And in fact, in the last 15, 16 hours, all the commentators in Hong Kong, including very distinguished senior counsels have all suspected that this is a sort of political manipulation. I do not want to repeat what has happened in London on the 30th of March, that is yesterday, with the UK parliamentarians debating on this issue, with the Prime Minister, Foreign Secretary, Justice Secretary, Lord Chancellor, all speaking with the same wavelength. And then the two judges, two very fine and distinguished judges, tendering their resignations. But having said all this, I remain very confident, because your question is whether I was worried. I was not worried. I remain very confident that we still have very fine judges in the judiciary, both local and overseas, serving at the various levels of the judiciary. And each one of them will serve with devotion in accordance with the judicial oath that they have taken. So Hong Kong will continue to benefit significantly from an independent judiciary who will adjudicate without fear or favor. And I'm sure that we will continue to see fine judges being appointed at the various levels of the judiciary. Thank you.
好，下一位記者嘅提問。我嘅右手邊
Next question. This reporter here, the back row. Chief Executive, I'm from Cable. About the two UK judges' resignation, one of the judges, Lord Robert Reid, commented that whether he would stay would depend on the political environment at the time when the Hong Kong NSL was implemented. And at the time, the comment is that he must make a stance if there is political interference over the judicial system. Now there is accusation that there is interference with the press freedom, freedom of speech. And is it appropriate to say that the resignation is because of political pressure? Do you think that the resignation is politically neutral? According to another piece of comment, Lord Robert Reid also took part in the ruling of Leung Kwok Hong's case about the electoral pass and privileges ordinance, and that the two judges' resignation had to do with the speech therapist case. Do you think that the resignation is a sign that they no longer believe in judicial independence in Hong Kong? And are you worried that this will spark a wave of resignation of non-permanent judges of the CFA in Hong Kong? Have you heard of any other possible resignation? And how will these two vacancies be filled? Will the judges come from the UK or from other common law jurisdictions? Another question is that, according to media reports, the chief executive election may be postponed further by 1 year because of the epidemic situation. Can you confirm that? First, about the chief executive election, at this stage, I have not received any notice. We will work according to the schedule, and that is the nomination period shall begin on the 3rd of April. You referred to the two judges' resignation yesterday. They're resigning from the seats of the non-permanent judges of the CFA of the Hong Kong SAR. I think I've covered the points, but let me repeat once again. If you've referred to Lord Reid's statement, his statement never refers to the allegation that there is no longer judicial independence in Hong Kong. So after implementation of the NSL, when he commented that he would continue to assess the position in deciding whether to resign, at the moment this is not subject to any interference. In fact, he continues, he continues to affirm that the judicial independence in Hong Kong is internationally recognized. So this is not a point about whether he's concerned about judicial independence in Hong Kong, and it doesn't conflict with the previous comments. As I explained just now, for 25 years, or in the past 5 years at least, when I appointed overseas judges as non-permanent judges of the Court of Final Appeal, I welcome them, and I welcome them in the sense that they support our judicial independence, and that includes final adjudication without fear of favor. So to say that after NSL has been implemented, judicial independence has now been interfered with, and that's the reason he wants to resign, I can understand, because the first thing when he was appointed that he said was he supported judicial independence. And if there is but that is not the case now, especially when the UK government suggests that they should no longer remain in office, and that if they don't resign, they should be deemed as endorsing the executive or administration of the Hong Kong SAR. Just like when the question was put to the Canadian judge whether her remaining in office would be lending legitimate support to the administration. And this should never be a factor at play. Justice McLaughlin, the Canadian non-permanent judge, already explained that it is irrelevant for overseas judges sitting on the Court of Final Appeal. They are never having anything to do with the administration of the Hong Kong SAR government. They're here to uphold judicial independence and the rule of law. So I think I've answered your question.
As to the way forward, we have permanent judges at the CFA. Yes, regrettably, 2 of the overseas non-permanent judges have resigned, but we still have 14 of them. 4 of them are from Hong Kong and 10 from the UK, Australia, and Canada. And it's not an establishment like the civil service. There is no fixed number. It's flexible. It's for the Chief Justice to decide the appropriate number. As the Chief Executive, and on every occasion in the past few years, the Chief Justice would have a discussion with me, and with the recommendation of the Judicial Officer's recommendation commission, it will be discussed at the LegCo, and with the consent of legislators, I will then exercise my power to appoint them. Some people say that there are expectations of judges in the CFA because after having gone through a vigorous mechanism, we see resignations. It's understandable that some people are disappointed. And as to whether there will be other appointments of overseas non-permanent judges, we will have to wait for the decision of the Chief Justice. Well, I don't have any knowledge about cases because we have an independent judiciary. I will not ask questions, and I don't know about what goes on in the judiciary. I will only, upon consultation, appoint national security judges. But after having appointed the panel, it will be for the judiciary to assign a particular national security judge to a certain case. With the promulgation of the national security law, there are lots of overseas politicians, organizations, and individuals smearing the national security law. That's completely unfounded. I would like to make it clear here. Also, for Hong Kong people to know, we see a lot of political manipulations going on. And I noticed that in one of the statements, there is an allegation saying that there is a high-level tug of war between countries. So we need to see what goes on behind the scene. I have full confidence of our judiciary. Of course, after the reunification, we need more recognition and support in our judiciary, but it's been over 2 decades. Our CFA and our judiciary is well renowned. Their cases have been cited as authorities in other jurisdictions. So I share the same view as my colleague, Mr. Ronnie Tong. We still have a solid foundation, a foundation on which we can uphold an independent judiciary where the court will exercise their power free from any interference. Next question. The one on towards the right in the middle, the gentleman. I'm from Mingpao. I have 3 questions. First, I'd like to ask about the epidemic. The WHO has just promulgated a strategic plan saying that end global COVID-19 emergency in 2022. There are similar views with some of our experts saying that the lethality of the virus has been reducing. Do you identify with that strategy? Do you think that Hong Kong can be the forerunner, a test ground for the mainland? And in relation to rapid tests, I'd like to get a clarification from you. Is it going to be a test before the universal compulsory testing? Any penalties if one doesn't do it? Another question is about overseas permanent judges. There is one such judge saying that they are canaries in a mine, and if they all leave, well, do you reckon that, as you've cited what Mr. Ronnie Tong said, that invitations can be sent out to jurisdictions such as Indonesia, Malaysia, etc., or Singapore? Well, you said that this has nothing to do with the national security law. But with the promulgation of the national security law, well, would there be any review done to clarify the provisions in the national security law? You've asked 3 questions. This morning I have read something about the chief executive officer of the WHO in relation to COVID-19. I didn't see anything about a roadmap. What I gather was that there are a number of scenarios. It's very likely that the virus will keep mutating to become weaker. Perhaps this will reduce the impact on our hospitals. But whether it will actually happen, no one knows. Well, I also have a team of experts in relation to the fight of COVID-19. The Department of Health will arrange for expert meetings to discuss about new information from the WHO. That includes vaccination and oral medication. It will be for the expert panels to discuss because I'm not an expert. But whether it is the WHO or government of different places, including the one here, we all hope that the epidemic situation will be brought under control as soon as possible so that we can all resume our lives and travel. Well, Hong Kong is different in many different ways from the mainland. We have got staunch support from the central authorities in our fight against the epidemic, in particular in the 5th wave. to find a way forward is for Hong Kong to resume our activities. I don't really understand what you said about being a forerunner and a trial ground for the mainland. As President Xi said, that lives and people are most important. It is hoped that the maximum impact to fight the epidemic can be achieved with minimum cost, so that our economy will be affected in the least way. Well, there are differences in our system, that is in relation to mainland and Hong Kong, so not all our measures will be aligned. I would like to also say something about another area, that is to make better use of the RAT kits in the COVID service kit. Well, the National Security Law was promulgated on the 30th of June 2020. You may recall that it is a national law. It is a national law that was approved by the NPC SC and then annexed and then included in Annex 3 of the Basic Law. I don't see any need for any review, which is to be done by the NPC. We can see how effective the national security law is. You may recall what it was like in the second half of 2019. Now we have stability. So we will continue to fully implement the national security law to protect the safety of Hong Kong people.
The speaker is not coming through. The NPJ mechanism is provided in the Basic Law, that is non-permanent judges. I think I've just read out the relevant article, and that if need be, we can appoint judges from other common law jurisdictions to sit on the Court of Final Appeal. It doesn't spell out an NPJ system as such. The mechanism is that we have permanent as well as non-permanent judges. We also have local and non-local, permanent and non-permanent judges. Their appointments are considered by the Chief Justice, and they field the suitable candidates. And once that is done, we have an independent commission, and that is the Judicial Officer's Recommendation Commission, which makes recommendations to the Chief Executive. And if this is accepted by the Chief Executive, the Chief Justice will then refer the proposal to the Legislative Council for endorsement before the final appointments are made. The whole process takes place in Hong Kong. This comes under Article 2 of the Basic Law, since we have high degree of autonomy in the Hong Kong SAR. There is no need to change this regime because this stems from, let me check which article of the Basic Law. Right, Article 82 of the Basic Law. It provides that as may be required, the Court of Final Appeal may invite judges from other common law jurisdictions to sit on the Court of Final Appeal. It doesn't spell out whether they should be non-permanent or permanent judges. Article 82 of the Basic Law remains. However, in terms of implementation, I think any Chief Executive will heed advice from the Chief Justice. So I think this is a question for the Chief Justice to consider. And it's true. Yesterday, Lord Hodge resigned, and it is true that he wasn't appointed until the NSL had been promulgated, and he only visited Hong Kong for the first time in November to preside over a case, and it wasn't until on that occasion that I could administer the oath. Now, I cannot disclose what I said to him, but as you can guess, If the Hong Kong NSL is so flawed, and yet the judge accepted my appointment 6 months after the NSL had been implemented, and he also personally came to Hong Kong to preside over some cases, then apparently I don't think this is directly related to the Hong Kong NSL. But as I made my statements in yesterday's press release in relation to major decisions, if this is based on a wrong judgment or assessment of the overseas government, or if it is based on undue political pressure or politically biased assessment, then we would be extremely disturbed, because we believe every judicial officer acts in an unbiased manner and preside over cases based on the law and evidence. In relation to other serving non-permanent judges and overseas judges of the CFA, I'd like to express my gratitude, because their participation in our judicial system have made great contribution to our Court of Final Appeal, and they also have laid a cornerstone of our judicial system. Now, it's now 12. I'll see you again tomorrow at 11.